మలబార్ గోల్డ్ అండ్ డైమండ్స్ ప్రపంచంలో పెద్ద జ్యువెలర్స్ లో ఒకటి ఇప్పుడు డాలస్ కి వచ్చారు. అందమైన తేలికైన జ్యువెలరీ డిజైన్ల నుంచి చేతో తయారు చేసిన అతి క్లిష్టమైన కలెక్షన్ల వరకు 20 దేశాల నుంచి 30,000 విధాల ప్రపంచంలోకెల్లా ఉత్తమమైన జ్యువెలరీ డిజైన్ల అనుభవాన్ని పొందండి. 5,000 చదరపుటడుగల విలాసవంతమైన షాపింగ్ ఏరియా మలబార్ గోల్డ్ అండ్ డైమండ్స్ షోరూమ్ ని డాలస్ లో విజిట్ చేయండి. ప్రపంచ స్థాయి జ్యువెలరీని కొనుగోలు చేసే అనుభవాన్ని పొందండి. మలబార్ గోల్డ్ అండ్ డైమండ్స్ now open in Dallas.
గెలుపే ఊపిరిగా, పట్టుదలే ప్రాణంగా, ఆశయమే గమ్యంగా పోరాడే యోధుడికి విజయం అన్స్టాపబుల్. ప్రశ్నల్లో మరింత ఫైర్, సరదాల్లో మరింత సెటైర్, మీకోసం మరింత రంజుగా. దెబ్బకి థింకింగ్ మారిపోవాలా? మీకోసం మరింత రంజుగా.
अब तू देख लेगा बच्चन साहब का खेल.
డౌన్లోడ్ ఆహా నౌ.
ఆకర్షణీయమైన చీరలు, అప్పురపరిచే ధరలు, అందరికీ నచ్చిన, అందరూ మెచ్చిన షో మన లక్కీ మహిళ. బోలెడంత ఎక్సైట్మెంట్, వండర్ఫుల్ విన్నింగ్ మూమెంట్స్.
ఎగ్జాక్ట్ చెప్పారు, మీరే గెలుచుకున్నారండి. కంగ్రాచులేషన్స్. $220.
సెలబ్రిటీ గోస్ట్లు, అదిరిపోయే పంచులు, సరదా సరదా కబుర్లు.
ఆశ దోశ అప్పడం పడ హెల్ప్ మీరు ఆడుతున్నారు.
ఇలా మరెన్నో మెమరబుల్ మూమెంట్స్ తోటి 3rd యానివర్సరీ జరుపుకుంటోంది మన లక్కీ మహిళ. Watch it live only on TVAT Telugu. మీ అందరికీ 3rd యానివర్సరీ శుభాకాంక్షలు.
మలబార్ గోల్డ్ అండ్ డైమండ్స్ ప్రపంచంలో పెద్ద జ్యువెలర్స్ లో ఒకటి ఇప్పుడు డాలస్ కి వచ్చారు. అందమైన తేలికైన జ్యువెలరీ డిజైన్ల నుంచి చేతో తయారు చేసిన అతి క్లిష్టమైన కలెక్షన్ల వరకు 20 దేశాల నుంచి 30,000 విధాల ప్రపంచంలోకెల్లా ఉత్తమమైన జ్యువెలరీ డిజైన్ల అనుభవాన్ని పొందండి. 5,000 చదరపుటడుగల విలాసవంతమైన షాపింగ్ ఏరియా మలబార్ గోల్డ్ అండ్ డైమండ్స్ షోరూమ్ ని డాలస్ లో విజిట్ చేయండి. ప్రపంచ స్థాయి జ్యువెలరీని కొనుగోలు చేసే అనుభవాన్ని పొందండి. మలబార్ గోల్డ్ అండ్ డైమండ్స్ now open in Dallas.
గెలుపే ఊపిరిగా.
Every week we bring in immigration updates. TVAT presents Talk with the Experts on the immigration topic. Now, our sponsors are Malabar Jewelers. They recently started a 300 store in Dallas area, Frisco area. Please visit their store. And movers.com. And don't forget that AHA OTT. It's a very good show that you want to, might want to go visit. Emily, what's the news today? I mean, all of a sudden we have this announcement from the State Department saying that they're going to do the visa stampings within the United States. What does that mean? Can I apply for the change of status visa stamping here? Can I apply for the extension of visa status here within the United States? What are the rules? And it's not been there for almost like 20 years. Can you explain more about this one, Emily?
This is definitely
visa stamping within USA. Yeah,
definitely big news, and will be a big benefit to people who've been stuck waiting for visa interviews, waiting for Dropbox appointments, stuck outside the U.S. So what this basically will do is allow certain people, not everyone, but certain people will be able to stay in the U.S. and mail their passport into Washington, D.C., get the visa stamped by the State Department in the U.S. and have the passport mailed back to them. We don't have a lot of specifics right now. So in the past, 20 years ago, we had this exact same option. And it was a pretty simple process. You filled out your DS-160, you sent in a money order, you sent in your photos, and they would mail you back your passport with the visa stamp in it in a few weeks. That ended after 9/11, partly because it didn't include a biometric or fingerprinting component to it. Then late last year, or I guess in the middle of last year, at the American Immigration Lawyers Association annual conference, the State Department had mentioned that they were entertaining the idea of bringing back what they call stateside visa renewals or visa revalidation from within the U.S. So the State Department is the government agency that's responsible for all of the consulates. They're the ones that are actually issuing the visas at consulates abroad. And on Friday, we get a report coming from Bloomberg, and it was also discussed in Times of India, saying that we are now looking at later this year, they're going to implement this. So they're now moving from we're entertaining the idea to it's full steam ahead, we're actually going to do this. Now, who all is going to be included? We don't know for certain yet. We have to wait until the details come out. We do know that it's going to be H-1B and L-1 holders. In the past, when it was H and L, it was only if you were already in H or L and renewing in the same category. So you couldn't go from H4 to H-1B and get the visa stamp in the U.S. before. We don't know at this point if this will now be allowed, because the way the article was worded suggested this is for renewals and possible initial visas for people who are maybe in the U.S. on F1, get their change of status to H-1B approved, they might be eligible as well. So we have to wait for all the details to come out, but this is just going to be a huge benefit for people who've had to miss business meetings because they couldn't travel because they wouldn't have a way to get back into the U.S. People missed important family events, marriages, births of kids because they couldn't travel and come back. Or then we had people stuck outside the U.S. not able to get back in because they got couldn't get an appointment or stuck in administrative processing, and they're having to work remotely and hope that they don't lose their job while they wait. So looking forward to this, and we'll just have to see what new information we get as the weeks come ahead.
Either way, I will take it as a very good news, Emily, because especially the visa appointment dates were backlogged to some of the categories almost 2.5 years. Now that will be reduced, though. Even if all the people may not be eligible for this visa stamping within the United States, even for the people who are not eligible, I think so they're going to be beneficial too. The reason is that if a bulk of the load will be taken by the State Department in Washington, D.C., though, it will ease up the pressures on the consulate, though. So, for example, if I'm going for H-1B extension stamping, instead of going there to India, I'm going to get the stamping here. That means that a slot in the consulate in India has opened up. In that way, then people will be if people who want to change the status also will get a priority in appointment because these extension people are out of the way. H4 extensions, L1 extensions, H-1B extensions, they will be out of the way. So they will not be standing in the line to get the visa. So that will ease up the pressure on the consulates, particularly the U.S. consulates in India, happening to be the longest waited consulates in the entire world after waiting period of 2.5 years. It also is that Chennai is the biggest U.S. consulates in the entire world. Seems that slowly Hyderabad might take over that place. But either way, that the ease of the pressure will be there. It's going to be good for the people who are going to get the stamping. Routine, mundane, extension stampings will be done here. Not only that, we are going to bring the jobs from outside the country to within United States because, hey, why do we need to send all our State Department people, send them to different countries, have them stamp there instead of having them work in Washington, D.C.? It's going to be a reduction of the money for the U.S. government, saving the money of the U.S. government too. That's a good step that they have taken from a long time. Anything else, Emily, before I go to questions?
Nope, I think we can go ahead.
Last digit is 459. You have any questions for us? 459, you have a question? Yes, sir. Go ahead.
Yeah, question.
Go ahead, sir.
Hello?
Yes, go ahead. We can hear you. Go ahead.
Myself and my wife both are on H-1B. I have H-1B and I-140 approved. So now I came to the premium, my extension is up. Can I include my wife's application, like converting from H1 to H4 plus H4 EAD together in the premium? And can this be approved in 15 days without any employment gap for my wife?
Yeah, so your wife is wanting to your wife is wanting to convert from H1 to H4 EAD?
Yes, without any employment gap, if that is possible, with the latest news you guys have shared on. Yeah.
Yeah, so as of now, USCIS has agreed to implement the settlement agreement in our lawsuit, and they're required to approve the I-129, the I-539, and the I-765 all together as long as they're filed together. That does include in premium processing, and since they did suspend the biometrics for the H4, there's no reason that it shouldn't be all approved together. So yeah, as long as everything's properly filed and nothing's missing from the I-539 H4 application or from the I-765 EAD application, all three should be approved together in premium so that she can avoid having that gap in employment authorization.
Okay, does the employer need to do anything if we change from H1 to H4 EAD?
No, the employer doesn't need to take any action. No, so the I-9, a lot of people get confused about that. They think that the I-9 is responsible for actually updating immigration with which status you're on. That's not the case. The I-9, the whole purpose of it is to make sure that U.S. employers only hire people who are authorized to work. So it's only at the time they're hiring someone that they're going to ask for your documentation, and only at the time that documentation is expiring are they going to ask you to provide it again. So her switching from H1 to H4 does not trigger anything for the I-9 because her H-1B has not expired. When it comes to the time that the H-1B is expiring, her company will then come to her and said, hey, please provide us with new work authorization. And at that time, she can give the EAD card instead, but she doesn't have to update them otherwise.
The next caller I'm going to invite is 349, ending 349. You have any questions for us? 349, you have any questions for us? $349, you have any questions for us? You're unmuted. 49. Let me try to admit one other person to see. 75, ending 75. You have any question for us? Phone number ending 75. Let me go with some of these questions if you would answer these questions, Emily. 849, you have any questions? Emily, the question that comes from YouTube is that if a person he has an adjustment of status, can they still go for H-1B stamping in India and come back? Or are they allowed to get the H-1B stamping in India and come back?
Yeah, so those that are in H-1B and have an adjustment of status have two choices. As long as they're maintaining H-1B status at the time you leave the U.S., you can get the H-1B stamp and come back into the U.S. in H-1B status without having any negative impact on your 485, and you don't need to have an approved advance parole to do that. Otherwise, if you go with the second option, then you have to have the approved advance parole before you leave, go and come back on advance parole. So it's either option works. So as long as you're in H-1B status, when you're leaving the US, you can go for stamping and come back in H-1B status.
3849, you have any question for us? 3849.
Hello, sir. Hello. Hi, Rahul, sir. And hi, Emily, ma'am. Thank you so much for serving the immigration community. I have only one question. So I am an H-1B. My wife is on H4 EAD. So I filed my H1 and H4 EAD like last month in the month of December. And it's our expiry date is on May 1st week, I believe. So now the question is, I asked her I heard about your lawsuit. Congratulations on that. So I asked, after this lawsuit, I asked my immigration attorney, what if I apply for upgrade for premium processing? Will all of them, like H1, H4, H4 EAD, will it be picked together? So they told it may or may not be. We don't guarantee. At the same time, I asked them one more question, what if H4, I'm not worried on H4 EAD much, but H4. So what if H4 is not approved by the time it's expired? My wife, does she have to leave the country and then come back, or is it automatically approved? So they told it will be automatically approved. You don't have to do any action, but on the status, it will be still showed as a pending. I just want your guidance.
Let me ask you, did you file for the EAD extension, or is it only EAD though? Is this the first time you filed for the EAD?
No, sir. So I'm not yet on EAD. I don't have any EAD. I'm on H1. My wife is on H4 EAD.
So your wife is on H4 EAD. You filed for an extension. Okay. Here is the answer for you. After May, after the I-94 expires, she can stay in United States, but she cannot work in United States. You got that? However,
okay. Yes,
there
sir.
is a hacking. There is an hacking. Our office did it. It's called hacking. We call hacking. I would recommend you get the H1 approved in premium processing. See if the H4 gets approved and EAD gets approved. If the H4 and EAD gets approved, you don't have to go with this step what I'm speaking about. If only your H1B gets approved and your wife's H4 and EAD does not get approved, there is something called Margarita extension. So what you do is
I heard about that.
There you go. So you follow the direction because this is done before we file the lawsuit though, okay? This hacking was being discovered before. Now, since your H-1B has been filed, it is not coming under the lawsuit filed by Stephen Brown in our office. You may have to do the Margarita extension though. So first try this one, the lawsuit one. If it doesn't work, because since you filed before, try the Margarita should work for you, okay?
Yes, sir. One more question, sir. I just heard the rumors, but I just want to hear from you once. So if H4 and H4 EAD is not approved within the I-94 expiry, will my wife go illegal? Illegal
no.
By any chance?
No, she will not.
No, okay.
As long as the extension is pending, she's fine. Okay?
Okay, sir. Thank you so much. That's all.
3849. Maybe the caller is not 3849. Sorry.
That's me only, sir.
That's sorry. Okay, let me go to the caller called 9384. 9384. Or 2554. Any of you guys can ask questions, guys. You're unmuted. 2554 or 9384.
2554.
Oh, go ahead. 2554. Go ahead.
Hi, sir. Thank you so much for taking my call. My name is Kumar. I'm from North Carolina. So my priority date is August 2011. I am current in both EB2 and EB3. So September 1st, my interview was completed. Then status changed to interview was completed and your case must be reviewed. But last Friday, I got notification from USCIS that your case was transferred to another office for processing. So So what it means? After interview, I put a number of congressman, senator, and ombudsman request. That's what only I did, sir. Now I'm confusing why it's transfer now.
Emily, what do you want to do with him?
Yeah, so transferring probably means that they have sent your case back to the National Benefits Center, which will do the final adjudication of the application, unless for some reason they decided to just transfer it to another field office that has more availability and more capacity, supposedly to speed up the processing. You know, we see this happen quite a bit, and really if you are not wanting to keep waiting for them, litigation is a great option to get this finally resolved, because you don't want your case to be just continue to be bouncing around. The date's been current for some time. You know, you already have been interviewed. You were interviewed when they could have approved it before the dates retrogressed. So yeah, I mean, it's the next step. It does happen from time to time, and I don't know why it's any faster for them to transfer it versus the officer that conducted the interview going ahead and adjudicating that case. But they're moving it elsewhere to get it adjudicated. That could mean more delay, even though they claim it's to speed things up. So you may want to consider litigation as your last step.
Can you explain what does the litigation mean if he wants to go to the court, and typically how much is the cost range for it? What are the, you know, what is there in the litigation? Is it something a major deal, or is it like a common thing that goes on?
Yeah, it's not really a major deal. I mean, definitely you think of, oh my gosh, I'm suing the government. I'm suing the United States. That's technically what's happening, but that's something that you're allowed to do by law. Any person who has to deal with a government agency has the right to sue that agency if they're not acting in accordance with the law, or if they're unreasonably delaying whatever application you've submitted to that agency. Now, when we say you're filing a lawsuit or you're suing the government, you're really not having to take any action. It's all done by the attorney. The attorney files a complaint online, so the attorney will just draft an explanation of this is what's happening in this case, this is why it's unreasonable, and under the Administrative Procedures Act, a court should tell the government to finish the job, to actually complete the adjudication. So all of that is just done in writing, and we file it electronically. And then we have to serve it onto the government by mailing it. So again, you as the person that's being represented doesn't have to do anything. Once that lawsuit is filed, the government then has 60 days to respond to it. Sometimes they'll file a motion or a response to the lawsuit, but what we normally see is they look into the case and they get the case to be adjudicated, and then they ask us to withdraw the lawsuit. So you never have to stand up in court, you never have to travel anywhere, you don't have to go on a Zoom and talk to a judge. You don't have any involvement. It's all done through the attorneys, and it's a relatively, quick and easy process. It's no more expensive than filing an H-1B extension with H4 and EAD and premium processing. So it's definitely something for you to consider.
9384.
Hello.
You have any question? Yeah, go ahead. 9384. Go ahead.
Hi, sir. Can you hear me?
Yes, go ahead.
Hi, I have two questions. One is on AC-21 and another one is on 60-day grace period on H-1B. So for the first question, AC-21, after 180 days of I-485 filing, if the employee changes the employer, right, and the new employer files I-485J to port the green card application, but the previous employer either revokes I-485 or I-140, is the green card still considered to be ported to the new employer?
Absolutely, it's put to the new employer.
Yeah, it's really important to understand that an employer cannot do anything to your 485. They have no power to revoke it. They can, even if they sent a letter to USCIS and said, this person no longer works for us, please withdraw their 485. USCIS cannot by law do that. The 485 belongs to you personally as the applicant. Only you or the attorney you hire can take any action on it. Now, the company can withdraw your I-140, but because it's been beyond 180 days of when your 485 was pending, that withdrawal does not have any impact on your 485 and allows you to still use AC-21, assuming that your I-140 was approved and your 485 is pending for 180 days. Then you can switch employers. The old employer can't do anything to harm your green card at that point.
Okay, thank you. My next question is about the 60-day grace period. As we all are aware of the tech layoffs going on these days, and usually with these tech layoffs, the person still remains in active employment, but the person doesn't logs in, right? So what I want to ask you is that from that day when the layoff happens and within 60 days, if the person has not started a new job on H-1B, but a new company has filed H-1B transfer petition with USCIS and the person has got the H-1B receipt number, transfer receipt number, is the person still in good state from H-1B status point of view?
There's no guidance on that. You're talking about a situation where you hit your 60 days, the transfer was filed within the 60-day grace period, but you have not actually started work for the new employer, right?
Right.
Yeah, there's zero guidance on that. We do generally recommend that you start work for the employer as soon as the transfer is filed, so it's within that 60-day grace period. The issue is that the reason we have no guidance is because USCIS generally never knows when you actually start working for the new employer. All they're looking at is at the time of filing, were you within the 60-day grace period? So I've not seen them ever come back and question when you started work for the new employer. They're just looking at the time the transfer was filed, was it within 60 days?
Emily, the question comes from Knowledge from YouTube. His question is that, can he change the company within 2 months or 3 months after he gets a green card? Will that cause any problem for him, for his green card or for his citizenship at a later date?
Absolutely. There's a big myth out there that everyone says you have to stay with the company for 6 months after you get your green card. Otherwise, you could get in trouble or your citizenship could be denied or something like that. That is not true. The American government is never going to force someone to continue working for an employer that they don't want to work for, especially once you have your green card. You are a free agent at that point. You can change to any job. You can change to no job at all. As long as the job is doing something legal, you are absolutely able to change the job even the day you get your green card. No requirements at all.
Emily, what do you mean change the job to a different profession? Let's say he got the green card in IT. Can he become a lawyer like you and still will not have any problem in getting the green card?
Yep, no problem at all.
Okay, the next caller will be 5282. You have any questions? Go ahead. 5282.
Hi, Rahul and Emily. I have a quick question. I was in H4 and filed for H4 and EAD extension. Then my I-40 got approved and filed for change of status. Now, my H1 got approved, and after that, on the next day, H4 got approved. So, what will be the what situation I am in now? It's I don't understand.
Got it. I got it.
This is totally Emily, common. Yep, go ahead.
Emily, before I have a little bit more questions where people need to know that, see, he moved from H-1B to H-4 and then he got his I-140 approved. Can a person get a permanent I-140 approval while on the H-4 and H-4 EAD?
Absolutely. Even without an EAD, there's no requirement that you be working to get the labor and I-140 approved. You don't even have to be in the country.
So now he has his H-1B approved and the next day H-4 got approved.
Mm-hmm.
What's the situation?
Yeah, and no one really knows the correct answer there. If you look at the last action rule, it would suggest that now you're in H-4 status because the extension was approved after the H-1B is approved. But there's an easy way to clear it up called the margarita switch. So you can travel to Canada or Mexico for less than 30 days, have a margarita, come back in and show whichever approval notice for the status you want to be in. So I'm assuming at this point you want to be back in H-1B status. So you show your H-1B approval notice, even if your H-1B visa stamp is expired, even if there's an H-4 stamp in your passport, it doesn't matter. As long as you have the H-1B approval notice with an I-94 and an old expired visa, you can come back in and they will grant you a new I-94 that clearly puts you in H-1B status. Now there's no question which status you're in.
Emily, let's say I go to Mexico, do the margarita switch, I come back on H1B. Now, after 1 week, I decide, no, I want to move back to H4. Can I do the same margarita switch?
Absolutely. Yeah, that's going to be so much faster and easier than filing another change of status back to H4. So as long as you have the H4 approval notice that has a new I-94 on it that is not expired, you can go back to Canada or go back to Mexico, have another margarita, and come back in showing your H4 approval notice. Now you'll get a new I-94 putting you in H4 status.
These are a little bit hacking, guys. Either you can go through change of status with USCIS and burden them, pay them all the money and pay us all the money, or you can get rid of us and just do the margarita. So it's so easier and it can be done so easy. These are the things that they have given to us. You need to use them instead of burdening the USCIS with a lot of paperwork. The next caller will be 9867. You have a question for us.
All right, sir. Just a quick question. So my priority date is June 2014, and I downgraded in October 2020, and we refiled again in the month of July of 2020. Last year, and I got the interview notice for the refiling. For the refiling EB2 application. We got the interview done, and it's been more than 4 months now. So still the status online, it shows it as interview was scheduled. So I'm wondering if I can take an informal appointment or something so that I can get to know the status, because all other my friends who got interviewed at the same time, their status got changed to the case pending.
Oh,
but my status
okay.
still shows it interview schedule. Yeah.
Emily?
Yeah, I wouldn't take any action because your date's not current. That's why they're not updating anything. And I know your friends had gotten the update saying case remains pending or interview completed or whatever it was. But that online case status does not reflect all of the back-end things that USCIS and those officers are doing. So just because the online case status did not update doesn't mean your case isn't progressing as it normally should. And especially we see that once it gets to a local office, sometimes you'll never get another case update until you get an approval notice in the mail. So I would not be concerned about it. I would not try Emma or an InfoPass. You're just going to be wasting your time because they're not going to be able to, probably won't even tell you the right information about what the actual case status is because the left hand doesn't know what the right hand is doing with USCIS.
1458, you have a question for us. 1458.
Yes, can you hear me?
Yes, go ahead.
Okay. Yes, hi, Rahul and Emily. Thanks for all the information, right? So yeah, we really benefit for your with your quick responses. So I actually have a green card, and I had a question. I still work for the same company. But my competition is asking me to work remotely, as a contractor. So, I think I heard about that I-9 discussion, right? So, how does I-9 come into picture? Can I work for the same company along with the competition as a contract? Yeah.
You're a green card holder? Absolutely.
We both are, me and Emily are immigration lawyers. As far as the immigration law is concerned, though, you absolutely have no problem working for two companies. In fact, my wife, when she was on the green card holder, and still now sometimes, worked for 8 different companies and gets W-2s from 8 different companies at the same time. Okay?
8 companies?
Now, 8 companies, yes. She's a healthcare worker. So all she needs to do is everywhere you go, you show them the green card to work. And let's say, for example, oh, you know what, in the weekend I'm free, I want to work for Uber and take the Uber and go drive. Can you do that? Absolutely. Can you work for Lyft at the same time? Well, that's a different company. Yes, go ahead, do it.
So I-9, should I declare it to the new company?
You
new
don't
company,
declare,
the I-9.
You do not declare that you're working. My wife does not declare she's working for 8 companies, though. She goes to the Memorial Healthcare. She gives the work your green card. Okay, in your case, a green card. That's it. You don't tell them what you're doing in the night. You're doing Uber in the weekend. You're doing Lyft. You don't have to tell any of those people. Okay. Now, if you want to tell,
Mhm.
that's up to you.
Correct.
You're welcome to. But you're under no obligation to tell them. Okay, the next person is 4430. You have a question for us.
Hi, Rahul.
44. Yes, go ahead.
Yeah, hello. Can you hear me? Yeah, yes, please.
Yes.
I have a question, sir. This is regarding the FOIA request for the USCIS. So, as this is a situation where my employer is not ready to provide me I-140 petition document, and I'm not in a, I could not change my employer because 6 months wasn't yet completed. So, my question here is, do we definitely need an attorney in order to file this FOIA request, or can we go on our own as a immigrant? And if we apply it, does my employer get to know about this FOIA request?
Emily?
You don't need an attorney to do it. You can absolutely do it on your own. It's a very simple process, and your employer has no knowledge of it. They don't contact the employer. It's completely done through the USCIS Freedom of Information Act office. So they will just take a scan of that file and send it to you electronically in your My USCIS account. And it takes maybe 4 to 6 weeks to get that. So yes, you should do it as soon as possible. No need to hire an attorney. I think we have an article on our website. If you go to rnlawgroup.com and search for FOIA, it'll give you the instructions on how to get that.
Thank you, Emily. But is there any is there any way that USCIS says or sends the information to my employer saying that as an employee have requested? Okay.
Nope. Thousands of people do this. Never had one come back saying my employer find out, because they don't tell the employer. USCIS does not communicate to the employer saying we've received a FOIA request on this file. The employer has no knowledge.
Is there any situation where when we are filling the request, what is the reason for this request? Do they ask us
you don't have to give
why
a
we
reason.
have been requesting in this manner?
Nope, it's your file. Your name's on it.
Well, if you are requesting for somebody else, you definitely recommend to go to a lawyer. But if it's your own file, you don't have to give any reason, none whatsoever at all. 7480, you have a question for us. 7480, you have a question for us.
Hi, Rahul and Emily. I have done my H1 transfer in the last year, October, in the Texas Service Center, but still it is showing as my case was getting reviewed. So actually the processing time was mentioned in the USCIS website is 2 months, but it is still showing as reviewed status. So what steps I need to take to get update regarding my status?
Is your employer willing to upgrade to premium processing?
No, he's willing to do the normal processing only. It is like 120 days now, but still it is under review.
Gotcha. Okay. So the main thing to be aware of is you as the beneficiary can't actually do anything. Only your employer or their attorney can do it. So the employer can contact USCIS to put in a service request for it being outside the normal processing time, or the attorney can do it, but you have no power to do it. If you were to call USCIS or put in a service request online, they would just come back 30 days later and say, you're not authorized for this information. We're not going to respond to you at all. So you can talk to your employer or talk to the attorney that filed the case and ask them, tell them, hey, it's outside normal processing time. Can you please put in a service request? But that's about it that you can do on your part. Premium processing is the better option, but if the employer is not willing to do that, then they should at least be willing to do a service request. Otherwise, litigation is really the next option, which if your employer is not willing to upgrade to premium, they're probably also not willing to litigate.
Emily, the question that comes from YouTube from Alok Sharma is that he's wanting to move to EB1C category. So he's trying to evaluate his situation to see, does he needs to go outside the country and work for that company for 1 year and come back into United States and then work for the company to apply for the EB1C? Or can he stay here and be on the payroll of the company which is outside the country?
No, unfortunately, you have to be physically present outside the U.S. for 1 year in order to be able to later come back and file in L1 or an EB1C category. and be aware that if you are going outside the US now to meet that 1 year requirement, every day that you come back into the US for brief trips are counted against that 1 year. So every day you spend in the US visiting is going to take an extra day for you to be able to meet that 1 year requirement. The clock doesn't start over, but coming back into the US during that year will delay your eligibility. But you definitely have to be outside the US physically, not just working for a foreign company while you're sitting in the US.
9867, you have a question for us. 9867.
Yes, sir. So just a quick question. Yeah, right. So, the downgrade and, we did the refile and it's been like more than 6 months now. And now I'm planning to change my job based on the EAD, but not planning to be on H-1B anymore. So does it make any kind of issue, like, going forward, probably like, until my date becomes current again, because probably 10 years down the line. So for the next 10 years, will it cause any issues, like, if I be on using this GCEAD?
So no, not at all.
The transfer.
Yeah, so you've got both I-140s approved, right? Your downgrade did get approved, and then the refile was done with the earlier approved EB2 I-140 approval.
Yes.
You've waited 180 days since the refiling was done. So you can use the EAD to move to the new employer. That is relatively safe. There's not a lot that goes wrong with a 485 once your I-140 is approved in the employment-based category, as long as you're switching to jobs that qualify for AC-21. So they just need to be similar jobs. One thing to think about, or to just kind of be aware of, that's happening right now with people, that's limiting people's ability to switch to the EAD, is the advanced parole processing time, because APs are taking 11 months to process. And so if you don't have the advanced parole and you're using the EAD, you have to wait until that AP gets approved before you can travel. Versus if you were on the H-1B, you could potentially go for H-1 stamping faster than waiting out an advanced parole. So that's the one thing to just be aware of, but otherwise it is relatively safe. And we have a lot of people that back in 2007, we kind of had the same issue where the dates were all current and then it retrogressed, and people were on the EAD for 10 years and they just kept renewing it. Just as long as you renew it timely, file 6 months in advance, and keep that AP valid.
Emily, what if the EAD is not approved in the time? What do you do?
The good thing with the EAD is there is an automatic extension. It's normally 180 days. So as long as you've timely filed your EAD renewal, when the current EAD expires, you get an extra 6 months to work while you wait for the renewal to come in. On top of that, right now, it's extended even further to 540 days to account for the longer processing times. So as long as you file about 6 months in advance, you get an extra 6 months. So hopefully USCIS doesn't take a year to process EAD renewals, since they don't have to worry about L2 EADs anymore and E spouse EADs. So yeah, just make sure you timely file that and you get that auto extension. But the auto extension does not apply to the advanced parole.
One other trick that I'm thinking about, Emily, is that you said that advanced parole extension is taking 13 months. And the rule says that we can only file within 6 months. Let's say, for example, my advanced parole is expiring I just got an approval and I only got it for 1 year. And it's only valid until February of 2024. What harm do you see if I just file an advanced parole extension right now?
Yeah, I'd definitely go for it. I mean, the great thing is the advanced parole and the EAD renewal are free. There's no cost to file them other than legal fees if you're working with an attorney. And so we're in kind of a new area where the APs are taking this long. This has historically not happened before. So we've never had to think about filing way early. But yeah, if your AP is only valid for a year and you just got it, file the renewal now. The worst they can say is you filed too soon. It's not going to harm anything on your existing AP. You can simply turn around and refile it. But at least that gives you the chance of maybe getting the new one on time.
5673, you have any question for us? 5673.
Hi, can you hear me?
Yes, go ahead.
Yeah. First of all, I would like to thank Rahul and Emily for helping us out on these questions.
And my question was like, my wife is on H-1B and she want to convert it to H4, like change of status. And while her H4 is in still progress, like it is taking now 6 to 8 months to convert or change to H4 status, can we again file H-1B while H4 is in progress?
File an H-1B extension or a transfer, or what type of H-1B would you file?
Or transfer.
A transfer? Yeah, you could do that. So you can file the H4. So you can actually, on the I-539 application, file, request a specific start date. So maybe she's thinking she wants to stay on H-1 now and she wants to transfer employers pretty soon, but 6 months from now she wants to be on H-4. She can list a start date that's 6 months from now, go ahead and file the change of status to H-4, and then file the H-1 transfer in between. I don't see any problem with that. Sometimes USCIS gets confused. They might send an RFE on the H-4 saying, hey, do you still want to do a change of status, or prove to us that you've continued to maintain your H-1 status, and then you can provide the new approval notice and the pay stubs for that. But I don't see any general problem with doing that.
So she can still go from, like from her. One other question I have.
Go ahead.
Yeah, so you're saying that now she's on H-1B, like she can file for a change of status to H-4, and within the process again, if it is not approved from change of status, she can still go again back to H-1B?
Well, you can't go back and forth, but if assuming she's still maintaining H-1 status with the first company and she wants to transfer to another company while the H-4 is still pending, that's fine. But if she stops working after the H-4 is filed, because to file an H-1 transfer, you have to be in H-1B status at the time of filing. So if she stops working, then this would not work.
And if the I-94 of the H-1B expires also, the transfer of the employer does not work. If the I-94 has not expired, you can still transfer to a different company as long as you're working for the previous company. The next caller is going to be 9384. 9384. Uh-oh. Can you unmute yourself, please? 9384.
Can you hear me?
Yes, we can. Go ahead.
Can you hear me?
Yes,
so
we
I
can.
have a question about validity of passport. So I am having H-1B transfer being done right now, and my passport is expiring, I think, in 8 months. So I wanted to know that does the passport needs to be valid for over 3 years for H-1B to be approved for 3 years? And the same question is for advanced parole. When we are entering the country, does the passport needs to be valid for more than 6 months?
For the H-1B extension, you only need the passport validity on the day you file the extension. So even if it expires afterwards, within 8 months, you said, you will still be eligible for the 3-year extension. For the advanced parole, though, it's the same thing is applicable. You're fine. You can enter. But if you're trying to enter on the H-1B, H-4, though, the rule here is a little bit different there. Because in that case, though, they may only give the I-94 until your passport expires. Okay? So, but when it comes to advanced parole, you're fine. When you're doing the H-1B extension within United States, it's fine. But when you're trying to enter into the United States, they may always check the I-94. They may only give a short duration, which may kick you out of the H-1B or H-4, whichever respective it might be.
So,
any more questions?
When we are entering, when we are entering the country on advanced parole, the I-94 that we get at that point, from my understanding, we usually continue to be in the valid status with the original I-94 of H-1B. So which means if I still have 2 years of H-1B, I-797 valid, and I'm coming on advanced parole, but my passport is valid for say 6 months, and they give me a I-94 of 6 months. So are you saying that after 6 months, I have to leave the country?
No, you don't have to. You're good. If the advanced parole expires, you can ignore it. The H1 and H4 are valid. You're good. But if you come back H1B and H4, okay? If you come back on H1B or H4N, and then it expires, though, that means that your non-immigrant visa expired. Non-immigrant stay expired. But if you come back in advanced role, they only give you for 6 months, you're good. Emily, questions from Ragini Gupta. What she's saying is that for the people who are from the YouTube, for the people who are applying for the B2 visa first time, do they need to only apply from the home consulate, or can they go to any other consulate? Let's say, for example, Vietnam.
Yeah, prior to COVID, it was definitely recommended that you apply only in your home consulate, because that consulate would be better able to determine your ties to your home country and your non-immigrant intent. But since COVID caused all of these consulates to be backlogged, there are some consulates that are taking 444 days to get a B2 visa interview appointment, and there are other consulates that are taking 40 days. So they have made it known that any consulate is fine. You can go anywhere that you can get legally to. You're not stuck with only the consulate in your home area.
9867, you have a question for us.
All right, sir. Thank you for taking my call again. So I have one follow-up question. Say, for example, if I keep continue employment with my AOS filed employer, can I take a side job? If I take it, then, what documents should I submit, and does it cause any harm to my H4 EAD going forward?
Emily?
Yeah, so as long as you're continuing with the company that sponsored your AOS, you can take a side job using the EAD. Just know that if you were planning on maintaining your H-1B status, you cannot use your EAD for a side job. By using that EAD, it converts you completely to EAD with both companies. But other than that, yes, you can work a side job. It can be any type of job. It doesn't even need to be related to what your AOS is sponsored for, as long as you continue to stay with that original AOS sponsoring employer, or use AC-21 to change to a different employer that is in the relevant field. The side job can be in any field.
Emily, Archana Pai from YouTube has this question. Her priority date is not current. Her 485 is pending. Is it normal to get an RFE on the medical? Why are they issuing an RFE on medical right now when my priority date is not current, is her question.
Yeah, unfortunately, it is normal. It doesn't make much sense, and especially if the date's nowhere near being current. You could end up having to submit a new medical in the future when the date does become current, if the current one expires. But we are seeing this from a lot of different field offices, service centers, or even scheduling interviews for people when the date is not current. Nothing to be concerned about. It's just bad use of government resources, I suppose.
Next question comes from 8140. 8140. Ending.
Hey, Rahul. Hey, thanks
how are
for
you?
taking my call. Hey, I'm good. How are you?
Good.
I had two questions. Question number one. Once our 485 is transferred to the National Benefit Center from any other service center, so in case if the AP and EAD renewal is due, so where do we need to send the extension?
Yeah, you can look at the I-765 filing instructions, and I believe it's based on the 3 digits that the receipt number starts with for your 485, not where the 485 is currently pending. So you still go by the receipt number, even if it's an old service center.
And it doesn't go by which address. It doesn't go by the address where you live in. It doesn't go where your application is pending. It goes by what is your receipt number. Is it SRC? Is it LIN? Based on that, you will have to go with that. Yeah, then it will give you instructions. If you're LIN, then which address you should file. You have to follow the directions.
Okay. So I have another question. Can the primary applicant can do the business on using the green card EAD?
You mean to start a business on the side?
Yeah, that's what he meant.
Yeah, you could do that. So again, if you're on H-1B and you're intending to use the EAD to start a side business, you would then be on the EAD for both the side business and your main job. But if you're using the EAD already, you can do anything you want on the side. As long as you have a job offer that supports the 485, and you're doing this separately, you can use that EAD to start a business.
This question is coming from, the next person is 7393. Do you have any question for us?
Hi, thank you. Are you able to hear me?
Yes, go ahead.
Yeah. So I'm actually currently on an O1 visa status with a pending 485, and I'm actually planning to travel to India soon. But I know I cannot enter back into India using O1 status. But my H-1B was previously approved in consular processing in November 2020. But I never got the stamping since I've been on O1 since 2020. So I was just wondering, like, if I do travel to India, can I get an H-1B stamping and enter back into the US on H-1B? No?
You could, but you would abandon your 485 because you have to be in H-1B status when you leave to be able to come back in H-1B status without abandoning your 485. So you need the advanced parole.
Okay, and I wouldn't be able to enter on O1 as well, right? So
Correct.
The only option I have would be to wait for my advance parole.
Right,
Yes.
and if it's taking more than a couple of months, you can litigate that. You can file a lawsuit due to the delay in the AP processing time. So we've been doing quite a bit of those. So you may want to get in touch with Stephen Brown in our office who handles those.
Emily, I heard one of the tough questions that's coming out. This is coming from Rahul Hamid. And I think so we both have to pay attention and probably need to argue on this question though. He filed a 485 application and within 180 days because of whatever circumstances he has to change the job. So does he needs to file the perm and I-140 again with the new company, or can he take this 485 application to the new company when he is leaving the job within 180 days?
Before 180 days has passed.
Yes, that's right.
Gotcha. Yeah, so we have to remember that the 485 filing never requires you to actually be working for the company that sponsored you. So if you don't even have to be working for that company during the 180 days, I think that you could still move to another employer that has a job offer available to you and then file your supplement J after the 180 days, or don't even file it and wait until USCIS issues an RFE on it. So the issue isn't stopping work within the 180 days, it's do you have a job offer to move to? And as long as you have that, you should be able to continue the process. I have not seen a situation where the 485 was denied because someone left within 180 days, except where, and this would only come up if the previous employer withdrew the I-140, and then USCIS issued an RFE on the 485 and there was no job offer still at that point. That's where the risk, I think, could come in. I don't know if you have a different opinion on that.
No, I'm fine, but I want to take a little bit precautionary steps, Emily, on it. I would not completely rely on this 485. If there is an interview conducted for this person on the 485, the USCIS officials may think that 180 days is where this person must be employed with, not that it's a job offer. They may implement that and may cause problems to the 485. As a precautionary step, I would have a permanent I-140 applied by the company that I'm going to and wait for this one to get approved with the 485. And if there is any problem, I'm going to rely on the perm of the new company. I will also maintain the non-immigrant status, especially if I leave the job within 180 days. I know that you have successfully argued many times in front of the USCIS and you argued those things, you have been successful. I still feel I want to be a little bit more cautious on it. 7393, you have a question for us. But especially people who are in this situation, though, please consult a lawyer immediately. Because a lot of people think, Emily, that they should just dump the 485 and forget about the 485 and then move on to H-1B. And some people even suggest to even withdraw the 485, which we both don't suggest it at all. But these people need to contact the lawyer if they have to leave the job. Now, safety is always to wait until 180 days, guys. I mean, you can avoid us too in that case. Everybody knows that. 7393, you have a question for us.
Hi, Rahul. I have a question. My firm was initiated with company A and it went to audit. And in meantime, company B is initiated my firm and it got approved. So later on, company A firm come through, but my priority date is still showing company B. So how could I correct that one?
What is your priority date in the company B?
July 2020, June 2020, but company A was March 2020.
Yeah, right now, there is no need for you to correct it, though. However, at a later date, though, you may want to file an amendment when this priority date becomes current and you want to file the 485, you can file an I-140 again. That's what I'm thinking, Emily. Why spend all the energy right now?
Yeah, so both I-140s are approved and they each have their own separate priority date?
Yeah, both.
Right. Both of them have their own separate priority dates.
Yeah, I mean, your employer or their attorney can try to do a service request and ask, that the prior priority date be ported or file the I-140 amendment now. But yeah, you could wait because especially with the 2020 priority date, if you're not going to be current anytime in the near future, you may leave this company before you ever would need to do anything on that.
And since it's so not going to, who knows you care of it? Yeah, that's the most that you can think about. But filing an amendment, spending all the money by the company or you, I don't know if it's justified because when the priority date is not becoming current in the next 5 to 10 years. Emily, one issue that is popping up a little bit more right now is the bigger companies like Meta, Google, and Microsoft. They are not going to file the green card applications right now. They put a freeze on recruitment. Thus, they're not going to file any perm labor certification application. What do you suggest for the people who did not get laid off or an H-1B and they never have any I-140 approval? What's going to happen with them? Because I don't know if they're going to take the freeze off in October of 2023 or will it take next 1-2 more years and then afterwards they start the labor certification, take 2 years. By the time our guy will complete the 6 years of H-1B.
Mm-hmm. Yeah, even if you feel like you've got plenty of time before you're going to hit your 6-year limit, there are companies out there that are able to file the green card and are able to sponsor the perm and get them approved. So I would start looking for other employment, even if you are with your dream job and you made it through the layoff situation. You really have to get to a point where you have an approved I-140. That approved I-140 is safety for you. That's your ability to continue to stay in the U.S. beyond 6 years. That's the ability for a spouse to be able to work. It just provides that additional benefit to where you can continue to stay here. And to not have that in place and be wondering and waiting to see when they're going to start this perm process again. And even if they started in the next couple of months, that means they're going to be taking another 6 months to decide on the job opportunity, and then another 7 months to get the prevailing wage, and then another 6 months to run their recruitment, and then they finally file. And what if DOL is auditing everything at that point because of unemployment in that area? So don't assume that when they restart, things are going to go back to how they were and it's going to be a smooth process to get the labor and I-140 approved in 2 years. It may even be longer. So definitely start looking for other employment, other companies that are willing to sponsor and start that process right away.
And also think of the alternative things though. If your spouse is on H-1B with a different company though, the spouse can get an I-140 approval though. That can actually save you because you can move on to the H4 EAD though. Those options are there. Maybe you want to preserve some of your H-1B if your spouse already has an I-140 approval though. then you can actually move to the H4 plus EAD right now and preserve some time of H-1B so that later on you can use the H-1B. Think of all different options. Please do not contact Reddy and PC when you are 5 months and 11 months and 22 days. You have 8 days left on your 6 years of H-1B. Don't contact us at that time. How can I stay in this country? Please don't do that. Don't contact us at that point of time. Please take the action necessary right now. There are many different alternatives that you have that if you want to plan it, but not if you would contact us 5 years, 11 months, and 22 days, and now you have only 8 days left. Emily, a question that came is that I am a dependent 485 application. My wife is a primary applicant. I'm a dependent. Can I do multiple jobs on a GC EAD?
Yeah,
Emily,
absolutely.
this question is the most asked question, Emily. Can a person do multiple jobs on OPT?
Yes. No
Can a
issues at all.
person do multiple jobs on STEM extension?
Yes. Well, there's a restriction there because they all need the 983, and there's a question of whether multiple employers are able to provide the level of supervision needed to conduct that training plan. So that one is a little bit restricted.
But it's possible. What about the H4 EAD? Can they do multiple jobs?
Yes, absolutely.
What about the H-1B? I'm working for Microsoft on H-1B. Can I also work for a consulting company on H-1B at the same time? And what's the
Yes, but you have to
it?
file, the second company needs to file what's called a concurrent H-1B. So it's very similar to an H-1B transfer or even an H-1B extension, all the same paperwork. It's just a different box that's checked on the I-129 form that specifies concurrent employment instead of change of employer or extension of status. But absolutely, you can do that. As soon as that concurrent petition is filed, you can start work for that second company.
Can the L2 EAD work for multiple companies?
Yep, no problem at all.
Can the main applicant in the 485 application, let's say my 485 has been filed with Coca-Cola and I got an adjustment of status EAD. Can I use that EAD to work with a side company, consulting company? Will that be a problem?
Yeah, no problem at all. As long as you have that main job offer that continues to support the 485, you can use the EAD to work in any type of job for any type of company.
Now, the question that is coming up, what do you expect the priority date as anticipation going on? Emily, now we don't see anything in the Congress. We see that the rest of the world numbers have increased the competition. Do you expect 2017 priority date to come in, or when do you expect that we're going to cross the January of 2015 for Indian national for either EB2 or EB3?
Yeah, I think it could be 5-10 years. It's definitely not going to happen quickly. It's going to take us the rest of this fiscal year just to get into maybe 2012 if we're lucky in EB2, because it's back in 2011 now, just looking at the filing dates. And we know that at the end of last fiscal year, there were still 40,000 applications that were left out and not approved in time before they ran out of the green cards. We've got to get through all those 40,000 just to get back to where we were in January 2015, but we don't have 40,000 visas available every year because of the 7% cap and because we don't have the spillover from family base. We have some this year, but that's not going to continue to happen every year. We're not getting the spill down from EB1 because more and more people are applying in EB1. And then rest of world EB2 is now utilizing most of their green cards, so there's no spill across from the rest of the world. So you're really limited to the actual 7% cap, and that's going to continue for the likely future. So it could be up to a decade.
So that 7% of the 40,000 is 2,800. Then you count the family members, that's approximately 1,400 green cards every year under EB2 and 1,400 families in EB3. So the total of 2,800 families for EB2 and EB3. So out of the 85,000 H-1Bs plus the J1 to H1s and the nonprofit organization H-1Bs like university, that's 100,000 H-1Bs, 60% of them are Indians. So after 60,000, we are limited only to 3,000 families. That's a very big backlog. At this point of time, guys, we still want all of you guys to keep writing letters that we're putting at the bottom. But at the same time, you need to prepare yourself to stay on the non-immigrant visa for a long period of time. Prepare mentally that, okay, I'm going to be staying in non-immigrant visa for a long period of time. What are the steps that need to be done? Rather than having a hope that, okay, next year I'm going to get the adjustment of status. That's not going to happen right now. The people who are in the pipeline may have to wait for a long period of time. That means that the people who have already filed the 485 application, the people who didn't file, at this point of time, keep fighting, but at the same time, be prepared for the worst, that you may have to stay for a long period of time on a non-immigrant visa. Emily, questions are coming out with regards to EB1 category. This gentleman is on EB1 category, Siley Honro, and EB1A category, and they have moved the 485 application to the non-local field office. So for example, if they are working in Orlando, they have moved their application to California. Why is that? Can the California, which is Los Angeles, can they approve my green card even though I'm in Orlando?
Yeah, this is very common. We started seeing it in the, with the October 2020 filings that went to the National Benefits Center as a way to kind of spread out the work and utilize all of the government resources, all the officers at the different field offices. They were commonly sending cases to field offices that don't belong to where you live. And those field officers were conducting the review of the 485 without interviewing and actually approving the 485 when the date was current. So no problem with that at all. It's actually a good sign. It means your case is moving forward and probably means that you're not likely to be interviewed, assuming everything looks good in the file.
Emily, before we leave, the last question that I will ask for you is that the last day of my employment is December 1st of 2022. However, I got paid until February 1st of 2022. When I looked into the USCIS website, which they recently said is the 60 days starts counting from the last day of employment. However, my company said that it is going to be February 1st. That's when the 60 days starts counting. We are speaking the 60 days is the 60 days of unemployment period when the I-94 is valid, when you leave company A to company B. Is it December 1st the 60 days starts counting, or is it the February 1st 60 days starts counting?
Yeah, USCIS really has not answered that question, and it was even raised in an ombudsman stakeholder meeting, and they didn't give us an answer to it, which might be a good thing because that gives us some more wiggle room to make some arguments. But I think mentally you need to assume that December 1st is the date and make sure that you get something filed within 60 days of December 1st. Now, whether that's an H-1B transfer or not, what you might want to consider doing if you want to buy more time is when you get to that 60 day from December 1st, you could consider filing a B2 change of status so that you at least have something filed within the 60 days. And then if you later end up finding another employer that's within 60 days of the February date and you decide to file a transfer, if that doesn't work out, at least you have the B2 that was properly filed and timely filed. There are a couple of other things to think about. If you have a valid visa stamp with that employer, you may not want to risk and go beyond 60 days from December 1st and try to argue the February 1st date. You can avoid that risk by actually filing your H-1B transfer as a consular processing. You wouldn't be able to start when it's filed, but once it's approved, because you have the valid visa stamp, you can go to Canada or Mexico, come right back. Now you're back in H-1B status. At the same time, if you were to have that valid visa stamp and go by the February 1st date and file late, if USCIS decides February 1st is not the date, it was December, and now you're filing that transfer late, and they deny the extension because of the late filing, that denial of the extension, you'll still get an approval in consular processing, but it's going to void your valid visa stamp. And then you have to leave and go for visa stamping and then come back. So for those, there's lots of different strategies and ways to kind of navigate that situation. So definitely consult with a lawyer before you decide on which date you're going to go by and what backup plans you can put in place and what's going to be safest for you to preserve your ability to get back into status later.
Thank you very much, Emily, for coming to the show. Thank you for the TVAsia audience and for the TVAsia to give a chance for us to answer the questions, because this sharpens our mind. You asking questions every week, this really sharpens our mind. It makes us on top of it. Thank you, audiences, for all it. Please do not forget, write letters. The draft that we have provided, TVAsia has provided the link before. Thank you very much.
మలబార్ గోల్డ్ అండ్ డైమండ్స్ ప్రపంచంలో పెద్ద జ్యువెలర్స్ లో ఒకటి ఇప్పుడు డాలస్ కి వచ్చారు. అందమైన తేలికైన జ్యువెలరీ డిజైన్ల నుంచి చేతో తయారు చేసిన అతి క్లిష్టమైన కలెక్షన్ల వరకు 20 దేశాల నుంచి 30,000 విధాల ప్రపంచంలోకెల్లా ఉత్తమమైన జ్యువెలరీ డిజైన్ల అనుభవాన్ని పొందండి. 5,000 చదరపుటడుగల విలాసవంతమైన షాపింగ్ ఏరియా మలబార్ గోల్డ్ అండ్ డైమండ్స్ షోరూమ్ ని డాలస్ లో విజిట్ చేయండి. ప్రపంచ స్థాయి జ్యువెలరీని కొనుగోలు చేసే అనుభవాన్ని పొందండి. Malabar Gold and Diamonds now open in Dallas.
గెలుపే ఊపిరిగా, పట్టుదలే ప్రాణంగా, ఆశయమే గమ్యంగా పోరాడే యోధుడికి విజయం అన్స్టాపబుల్. ప్రశ్నల్లో మరింత ఫైర్, సర్దాల్లో మరింత సెటైర్, మీకోసం మరింత రంజుగా. దెబ్బకి థింకింగ్ మారిపోవాలా? మీకోసం మరింత రంజుగా.
अब तू देख लेगा बच्चन साहब का खेल.
డౌన్లోడ్ ఆహా నౌ.
ఆకర్షణీయమైన చీరలు, అప్పురపరిచే ధరలు, అందరికీ నచ్చిన, అందరూ మెచ్చిన షో మన లక్కీ మహిళ. బోలెడంత ఎక్సైట్మెంట్, వండర్ఫుల్ విన్నింగ్ మూమెంట్స్.